All right, and we're live. Hello, everyone. I'm Leonard French, your favorite copyright attorney, and we're here to do a new lawsuit review. What I'm not here to do is speak about the politics of the situation, so you can rest assured that I'm not going to be dipping into who's wrong and who's right or anything like that. This is just going to be a really interesting lawsuit review because we don't see this kind of thing all the time. This is a weird lawsuit. This is a kind of a crazy situation. And so I'm going to give you a little bit of background, and then we're going to go over the lawsuit itself. And then there's some exhibits tied to the lawsuit. And the exhibits kind of lead down a rabbit hole, and I'll give you the beginning of the rabbit hole and let you figure out the rest, because I honestly have no idea what's really going on here. I try to avoid, I really hate politics. Like, I believe in the philosophy of politics and philosophy of government and governance and all of that, but then when it gets to like the infighting and all that, I really just, I try to bow out and stay away. But you know, it's kind of impossible to avoid if you also believe in people and society and things. So I find myself just in the middle of all of that, and I kind of hate it a little bit. So I'm more interested in learning something from a lawsuit. So let's jump in and see what's going on. Our plaintiff here is a man named Frederick N. Eshelman, and as best as I can tell, this is the same person. He's a PharmD, so he's a pharmacological, has some kind of pharmacological degree. He's done some sort of pharmacological or pharmaceutical product development. He owns the Eshelman Institute for Innovation, and I haven't gone super deep into exploring who this person is, but if we go to his website, it says that he is the founder of Eshelman Ventures, an investment company primarily interested in private healthcare companies, previously founded and served CEO, executive chairman of pharmaceutical product development, PPDI, on NASDAQ, excuse me. He has also listed himself here. After PPD, he served as founding chairman of the largest shareholder of Furiex Pharmaceuticals. He's chairman of the Medicines Company. So he has a lot of background in pharmacological or pharmaceuticals. But that's not what brings him to us today. It's this story. A pro-Trump nonprofit hit back at venture capitalist donor who gave $2.5 million to uncover election fraud. And our story today is that then he demanded it back. So let's jump into the lawsuit and we'll see what's going on here. This is the lawsuit in the United States District Court for the Southern District of Texas. This is Frederick N. Eshelman versus True the Vote. And it's kind of self-explanatory. We'll see what's going on here. This is a verified complaint. That means that he has signed the complaint. He verified it by actually making a statement at the end that we'll see, and he signed it with his own name. And that's kind of different because you don't have to do that in federal court, but he did. So this is a verified complaint, and it talks about how he's the plaintiff and how defendant is True the Vote, a 501c3 not-for-profit corporation. Am I a little loud here? I'm going to turn myself down. A not-for-profit corporation organized under the laws of Texas with its headquarters and principal place of business in Houston, Texas. Defendant may be served through its registered agent. That's a normal thing. You can have a registered office and then papers go to the registered office. So let's just see what's going on here. I'm not really worried about jurisdiction. We know that we've got diversity jurisdiction because the amount in controversy exceeds $75,000. That means it's over $75,000. At least $75,001 will get you into federal district court when the parties are citizens of different states. So here we have North Carolina and Texas. The plaintiff seeks the return of more than $2.5 million in conditional gifts to defendant, in addition to contractual and economic damages, attorney's fees, and other declarative and equitable relief. So usually that's injunctions as well as declaring something is true or not true. Facts. Immediately after the November 3rd general election, plaintiff decided to support efforts to investigate allegations of illegal and fraudulent conduct in connection with the 2020 general election. Defendant holds itself out on its website as the country's largest voter rights organization, that's True the Vote, and notes that it is well known for its ability to lead national unified plans to protect election integrity. In describing its mission, I don't know how I mixed those words up. Defendant describes its operations as a network hub working together with other organizations to implement targeted election integrity initiatives to expose and detect or deter election fraud. I can read tonight, I'm sure. On or about November 4th and November 5th, plaintiff Fred Eshelman spoke with defendant's president, Mrs. Engelbrecht, about defendant's Validate the Vote 2020 project. During those conversations, Ms. Engelbrecht represented to plaintiff, Mr. Eshelman, that defendant had organized its Validate the Vote 2020 effort to ensure the 2020 election returns reflect one vote cast by one eligible voter and thereby protect the right to vote and the integrity of the election. Ms. Engelbrecht further represented to plaintiff during those conversations that defendant believed those efforts were necessary in light of significant evidence that there were numerous instances of illegal ballots being cast and counted in the 2020 general election. Ms. Engelbrecht explained to plaintiff that defendant had developed a multi-pronged plan referred to as its Validate the Vote 2020 initiative to investigate, litigate, and expose suspected illegal balloting and fraud in the 2020 general election. As part of its Validate the Vote 2020 plan, defendant intended to 1. Solicit whistleblower testimony from those impacted or involved in election fraud, 2. Build public momentum through broad publicity, 3. Galvanize Republican legislative support in key states, 4. Aggregate and analyze data to identify patterns of election subversion, and 5. File lawsuits in federal court with capacity to be heard by the Supreme Court of the United States. And there's a footnote here, and there's a one-page summary attached as Exhibit 1. So let's take a look at Exhibit 1 here. Exhibit 1 is, here we go, the True the Vote, Validate the Vote project. So that's pretty much what we just read. They have a funding estimate here. The whistleblower campaign will be $2 million. Data and research will be $1.75 million. Litigation will be $2.5 million in district court, $375,000 in the appeals court, and $700,000 for the Supreme Court effort, for a total of $7.325 million. And the legal strategy involves an attorney named Jim Bopp, True the Vote General Counsel, lead attorney in Bush v. Gore, and Citizens United. So that's no small. That's not a empty resume there. That's a pretty good resume to say that you were the lead attorney on Bush v. Gore and Citizens United, both of which were won in favor of, I'm assuming, Jim Bopp's party, which would be Bush and Citizens United in those two respective lawsuits. So that's not an empty resume there. So that's a real thing. That's going to cost some money, and that seems to be not. There's no reason for me to doubt his ability as counsel, since he's got a good track record there with his plaintiffs. Again, I'm not commenting on the politics of it. I really don't care about that for the purposes of our stream. He won for those parties, and that's a big deal. So we go back up to footnote 1 and start at paragraph 11 again. With respect to its plan to file lawsuits in key states, Ms. Engelbrecht represented that Jim Bopp, attorney affiliated with defendant, would file lawsuits in the 7 closest battleground states with an eye towards serving subpoenas on state election officials to produce relevant election data. Based upon data subpoenaed in those 7 proposed lawsuits, Ms. Engelbrecht represented to plaintiff that defendant then intended to undertake sophisticated data modeling and statistical analysis to identify potential illegal or fraudulent balloting. Engelbrecht advised plaintiff that the expected cost would be $7.325 million. Based upon information and belief, the amount was well in excess of the defendant's 2019 budget, which plaintiff understands was approximately $750,000. So about, 10% of their budget was they were going, 10 times over their budget. Based upon Engelbrecht's representations regarding defendants' comprehensive plans to investigate, litigate and publicize illegal balloting and other election fraud as part of its Validate the Vote 2020 efforts, plaintiff agreed to give an initial gift of $2 million to defendant on the condition that the funds would be used to fund the initial stages of the Validate the Vote project. Specifically, $1 million of that initial pledge was intended to fund efforts to communicate defendant's findings via the contemplated litigation. Plaintiff advised he would contribute more as the project progressed. Subject to those conditions, plaintiff wired $2 million to defendant on November 5th, 2020, using wire instructions provided by Engelbrecht. Engelbrecht inferred to plaintiff that the legal expenses might exceed the initial budget. In order to maintain what he thought the momentum. On November 13th, plaintiff agreed to give defendant an additional $500,000, so a total of $2.5 million, subject to the same condition that those funds would be used to fund defendant's Validate the Vote 2020 efforts. Subject to those conditions, plaintiff wired the $500,000 on November 13th using wire instructions. Time was of the essence to the efforts outlined in defendant's Validate the Vote 2020 plan because of various state and federal deadlines for certification of state election results and electoral college votes. After agreeing to conditionally give defendant funds to support its Validate the Vote 2020 efforts, plaintiff regularly and repeatedly sought substantive updates from Engelbrecht and other individuals associated with defendant. Specifically, plaintiff sought specific and actionable updates regarding progress on defendant's purported investigation, litigation, and communication efforts in key states. Plaintiff's requests were consistently met with vague responses, platitudes, and empty promises of follow-up that never occurred. So they got the money, and then he's claiming that they stonewalled him. Specifically, in response to requests for specific something and data related to potential whistleblowers and how their allegations fit into the overall narrative, Engelbrecht would simply respond with vague comments like, "We are vetting," or "They are solid." Ms. Engelbrecht also routinely ignored repeated requests for memoranda and written reports to summarize defendants' efforts to identify and obtain information from whistleblower witnesses. I mean, on one hand, it sounds like maybe True the Vote was just overwhelmed. On the other hand, they could have just been taking his money and stonewalling him. I don't know. This is just a complaint, by the way. This is not a finding. Nobody's guilty of anything yet. This is just a claim. In response to questions about defendant's litigation strategy in the 7 key battleground states targeted by the Validate the Vote initiative, plaintiff was only ever provided with 4 complaints filed in Wisconsin, Michigan, Georgia, and Pennsylvania. He was not provided any specific update on the status or strategy behind those cases, nor was he provided any explanation as to the status of litigation in the remaining 3 states. Defendant failed to consult with or inform plaintiff of that decision, even though the decision amounted to a material deviation from the Validate the Vote plan that plaintiff conditioned his gifts upon. Let me take a quick look here. Did they say what states? Yeah, so they're Arizona, Nevada, Georgia, North Carolina, Pennsylvania, Michigan, and Wisconsin. And apparently 3 of these, I guess it was Arizona, Nevada, and North Carolina, maybe? Yeah, they apparently did not sue. Defendant's consistent delay and inability to make progress on the goals that Engelbrecht described to plaintiff just after the election suggested that many of those goals might not be met, since many important deadlines relating to state election results were rapidly approaching. Given defendant's lack of progress on the goals articulated in its Validate the Vote plan and the rapidly approaching certification deadlines, plaintiff decided to call a meeting with Engelbrecht and other individuals associated with the Validate the Vote effort. Specifically, plaintiff sought detailed information and reports on voter data that defendant had collected, identities of any alleged whistleblowers along with the information they would testify to and their vetting status, the entities and resources dedicated to performing statistical analysis on available voter data, the expected timeline to obtain such statistical analysis, the status and strategy update for the litigation in each of the 7 battleground states, defendant's promises to provide media content for circulation, and defendant's efforts to raise the remaining money to fund the project. That meeting took place by teleconference on November 16th and was attended by Engelbrecht and Attorney Bopp, among others. The November 16th meeting unfolded in a manner similar to the many others that had taken place regarding the Validate the Vote effort since November 5th, which is to say that Engelbrecht and Bopp failed to engage with or respond to plaintiffs' requests for specific actionable updates on the issues set forth and proposed plans to accomplish all of the efforts he had originally agreed to fund. According to PACER records, that's the official government public access to courts electronic records system, defendant voluntarily dismissed all of the 4 pending pieces of litigation it was pursuing on November 16th. Upon information and belief, plaintiff further understands, upon information and belief, that the decision to abandon those cases was made in concert with counsel for the Trump campaign. Defendant undertook to voluntarily dismiss its 4 active litigation matters without consulting or informing plaintiff of that decision, even though that decision amounted to a material deviation from the scope of the program upon which plaintiff's gifts were conditioned. By November 16th, it had become clear that to plaintiff that defendant's delays and inability to make progress on its stated goals meant that it would be unable to execute the Validate the Vote efforts that plaintiff had agreed to fund. Since defendant had failed to comply with the conditions on plaintiff's gift, plaintiff sent an email to Ms. Engelbrecht on defendant's behalf early on November 17th to request a refund of the balance of his $2.5 million contribution. In relevant part, that email read, quote, "Please wire the balance of my contributions to my account as shown below. Also send a full accounting of all money spent out of the $2.5 million, which should be de minimis since nothing was accomplished over the 10 or so days. Thank you for a prompt response." And this is apparently listed as Exhibit 2. So Exhibit 2 here is this email, which is what I just read. And he provides his redacted account number here. He redacted this. I did not have to. That's a good idea to redact your account number when you're posting it in an exhibit. In light of the upcoming in light of the upcoming vote certification deadlines and his desire to use the funds he had conditionally gifted to defendant to support other election-related efforts, plaintiff sent Ms. Engelbrecht another email requesting repayment early on November 19th. In relevant part, that email read, quote, "Please acknowledge receipt of my previous email with wiring instructions to return the bulk of the money I put in. This is needed immediately for other activities towards the common goal." And that one's going to be Exhibit 3. And so Exhibit 3 is this email. And so it's just this email showing that he sent an email, That's all it is. Again, defendants failed to respond to plaintiff's request. Given defendant's repeated refusal to respond to plaintiff's request for repayment, counsel for plaintiff sent a letter to defendant on November 1st regarding the directed donations specifically made to True the Vote in the 2 weeks following the election, totaling $2.5 million. Specifically, that letter requested that defendant confirm before 7 p.m. on November 22nd that it intended to return the conditional gift and it would undertake a wire transfer by 10 a.m. November 23rd. 10 a.m. is an important time for wire transfers. If you get your wire transfer scheduled by 10 a.m., it usually goes through the same day. So that is Exhibit 4. And Exhibit 4 here, I keep using the wrong direction on my mouse, is from Venable LLP, which I'm assuming is a law firm. And it says, "We represent Fred Eshelman," and they request the return of the 2.5 million, or at least the balance of it. "We understand that True the Vote may have engaged in some limited activities in furtherance of the specific projects for which Mr. Eshelman agreed to make a donation. With appropriate documentation and accounting, Mr. Eshelman is willing to allow True the Vote to retain some of the funds he donated. Given the lack of information provided to date about these activities, we anticipate this number will be relatively low, but are willing to discuss. Please contact me immediately if True the Vote believes it is entitled to retain any of these funds so we can maintain our timeline. As should be clear from the prior correspondence you have had with Mr. Eshelman, no further funds should be expended from the money he donated. In addition, True the Vote must retain all necessary records to justify any funds that were expended previously. If I do not receive confirmation that you intend to return the funds to Mr. Eshelman, and if we do not receive proof of a wire transfer by Monday morning, we will be forced to take legal action to obtain redress. Given the reasonable foreseeability of litigation, True the Vote must immediately take steps to preserve all hard copy and electronically stored information, evidence of relevant to Mr. Eshelman's claims. True the Vote must also immediately cease all data destruction, scheduled or otherwise, and undertake efforts to prevent the destruction or disposition of hard copy materials or electronically stored information that may contain relevant evidence. We are hopeful that this matter can be resolved quickly and amicably. Please know, however, that Mr. Eshelman expects his money back immediately, as he has other efforts he wishes to fund that have very short timelines. We look forward to your prompt response. Now, I'm not trying to be mean to Mr. Eshelman or anybody here, but that last paragraph really gets me. I'm like, wait a second. Did he really only have $2.5 million to donate, and he donated everything he had, and now he needs it back so he can spend the money? Or is that just a paragraph of platitudes that you would say when you're trying to get your money back? Like, by the way, we need this back for a legitimate purpose. I don't know. You take it for what you will. Back to our lawsuit. Ms. Engelbrecht responded by email 5:30 p.m. the next day, but did not confirm the plaintiff intended to return the money. Instead, defendant continued to engage in dilatory or delay tactics, claiming without any specificity that it did not expect to have complete information on what it had spent on the project this month until next month, that it had made commitments to many people, including whistleblowers, that it must fulfill, that it had committed to activities that we must complete. And that's Exhibit 5, I think. Actually, let me just check that. That is Exhibit 5. Before I prematurely show you these exhibits. And here's where there is something of a rabbit hole to start going down. Dear Mr. Jacobs, since Mr. Eshelman asked for his money back, we have started to put together the costs and expenses of the project that he helped fund. Unfortunately, we only have a few invoices and other receipts at this point, with many more forthcoming. And that's normal. Normally a vendor would do some work and then bill you within a few weeks or maybe even a few months. Most vendors within a few weeks, but I'll admit that sometimes I've billed somebody a few months after I did the work. Unfortunately, we only have a few invoices. Yeah, that's what I just said. In addition, we have made commitments to many people, including whistleblowers, that we must fulfill, and we have committed to activities that we must complete. Finally, we have an invoice for $1 million from Old Town Digital Agency, LLC, which Mr. Eshelman asked us to pay from his gift, which is not resolved. We have contacted them to get information about this, but we have not heard back. This invoice must be resolved before we are able to provide you a report of what we have spent so far on that project. So remember that we're going to look up Old Town Digital Agency in a moment and see what the heck that is. We have provided regular reports to Mr. Eshelman directly, which of course he didn't say anything about in his lawsuit, so I don't really know if he's actually been getting these regular reports. And through extensive communication with the people he said he is working with, I assure you that we have spent the money on the project we discussed with Mr. Eshelman. I am happy to discuss this further with you once we get all the information together. I hope we can resolve this. Nonetheless, defendant's response did acknowledge that plaintiff's gifts had been conditioned on their use in support of the Validate the Vote 2020 efforts. Specifically, Ms. Engelbrecht assured plaintiff's counsel that they had spent the money on the project we discussed. Shortly after on November 22nd, plaintiff's counsel responded by email in relevant part, Mr. Eshelman expects a wire of at least $2 million first thing in the morning. Based on the limited reports he has received, we cannot believe that True the Vote has committed more than $500,000. That's Exhibit 6. And that's what he says here. If we see the $2 million set to wire, we can hold off on filing a lawsuit, which will seek a full refund plus attorney's fees and damages. As it had already done 3 times before, defendant again refused to respond and failed to initiate a wire transfer. In light of defendant's failure, plaintiff again through counsel sent one more final demand letter to defendant on November 23rd, and that's this letter, I think. Ms. Engelbrecht, I write subsequent to my email correspondence, November 22nd, despite our reasonable request that True the Vote return at least $2 million, totaling of the conditional gifts totaling 2.5 million, no such wire transfer has materialized. In light of True the Vote's repeated failure to comply with Mr. Eshelman's request for repayment, this will serve as notice of our intent to file suit against True the Vote in federal court tomorrow, Tuesday, November 24th, if True the Vote fails to remit $2 million by wire transfer today. First, a summary of the underlying facts, and then they go into the underlying facts that we've pretty much covered here. And then they say that he repeatedly sought substantive updates and he was really not given any. And so they've summarized everything here. I think this is nothing new and there's nothing in this that we need to go over, further elongating this, this live stream. Let's see if there's anything attached here. As you are no doubt aware, Texas law provides that donors have a right to revoke a gift whenever a gift remains conditional upon a future act. And then they go into some case law. There appears to be no dispute that Mr. Eshelman's gifts were made contingent on their use to fund the Validate the Vote 2020 effort, and that those efforts remain largely unfulfilled. And so they go into some more legal threats that other courts have held that a nonprofit entity's failure to abide by the condition of directed donation amounts is a breach of the underlying gift agreement, remediable by a return of gifted funds. And so they ask for the return of the balance of the 2.5 million and an accounting of the funds that were used. In that letter, plaintiff notified defendant that if it failed to initiate a wire transfer of $2 million, plaintiff would be forced to seek judicial intervention. 30 minutes after the deadline, Mr. Bopp responded to plaintiff's letter on his law firm's letterhead. In that letter, defendant offered to return $1 million of the 2.5 in conditional gifts in exchange for a waiver of claims and an agreement not to file suit against defendant. That's interesting. They'll give $1 million back, but you have to sign everything else away. If really they owe him the rest of his money back, they really can't then add conditions onto it. They would just give him his money back and hope that he doesn't sue them. And if you're going to give all the money back, then maybe you can further ask for a waiver of that we're settled here, please, sign here that you received the money and that we're all settled. But if you're only going to give $1 million of $2.5 million back without an accounting, I mean, I'm on Mr. Eshelman's side here. That sounds like they didn't do what they were supposed to do. Again, this is a complaint. We only have one side of the story, and there is some more to that article that I showed. True the Vote says that there's lots more that they did and lots of expenses, and they really do need time to account for the invoices and things. But let's continue and see where the rest of this goes. And then, of course, here's the letter. And so this is from the Bopp Law Firm. Dear Mr. Jacobs, we represent Ms. Engelbrecht. Please direct all communications to us. Our client has advised that she's been trying to resolve the matter. True the Vote has received an invoice from Old Town Digital Agency. Ms. Engelbrecht inquired as to what the agreement or services this invoice was based upon, as she was unaware of any specific services that had been provided to date by Old Town Digital Agency. Here's where that name comes up again, and then here's another name, someone named Dikran Yakubian. I'm probably butchering the name. I apologize, Mr. Yakubian. But she received an email from Dikran Yakubian that this $1 million invoice was canceled. So let's just remember that. I'm going to just go over here and just type this into my search engine off screen, and then we'll bring it back up later so we can go down this rabbit hole together. After reviewing the expenses and obligations incurred regarding this project, including commitments made to whistleblower, our client is prepared to offer your client a return of $1 million. This return will be contingent upon your client and others he's associated with entering a written agreement to waive any claims regarding the donation made by Eshelman to True the Vote. Furthermore, this return is contingent upon his agreement and Old Town Digital Agency's agreement not to file suit against True the Vote while the written agreement is being finalized. True the Vote will wire the $1 million refund to Mr. Eshelman within 24 hours of execution. Okay, so I don't know about this part where it says that the the agreement not to file suit is just while the agreement's being finalized. I'm not sure what that means. Does that mean you can sue after the agreement is being finalized? I wouldn't think so. I would think the agreement would be, we're not going to sue, so then once it's finalized, you still can't sue. So it's interesting wording there, but I'm not sure if that's effective wording. Given the reasonable foreseeability of litigation if no settlement can be reached, Mr. Eshelman and Old Town Digital Agency must immediately take steps to preserve all hard copy and electronically stored information that may contain evidence relevant to the donation by Mr. Eshelman and regarding Old Town Digital Agency's $1 million invoice, which I thought was canceled, and any agreement with True the Vote. Likewise, Mr. Eshelman and Old Town Digital Agency must also cease data destruction, scheduled or otherwise, and preserve evidence. Please respond to True the Vote's offer by noon on Tuesday, the 24th. Okay. As of the time of the filing of this verified complaint, defendant has still not initiated any wire to plaintiff. I'm assuming that he hasn't also signed away his right to sue because, well, we're here. We're looking at the lawsuit he sued. In light of defendant's refusal to engage plaintiff's reasonable requests, plaintiff fears the defendant may be currently disposing of plaintiff's funds in support of unrelated projects or bad faith expenditures supposedly in support of the Validate the Vote project. While plaintiff is forced to litigate this to obtain what is rightfully his, relevant deadlines are rapidly approaching. Each day that passes makes it less likely that plaintiff will be able to use the funds defendant is wrongly withholding for the purpose he initially intended them to be used, that is, to support efforts to investigate allegations of illegal and fraudulent conduct in connection with the 2020 general election. And of course, we know that Attorney General William Barr has already said that there was no significant voter fraud, and he's on the Trump administration side, so there isn't really any huge dispute here about whether there was, incredible voter fraud. Although I'm certainly aware of lots of rabble-rousing and loud voices saying that there was voter fraud. So far, me as an attorney and apparently Attorney General as an attorney have not seen any significant voter fraud. Certainly in every election, there are instances of it. You can find 1 or 2 or 3 instances of it. I believe there was an attorney in Florida who told people to register in Georgia, and then he did, and now he's being investigated for that. That's a highly illegal act, and you don't do that. But let's finish this here and then go down the rabbit hole. So count 1, breach of contract. So because it was a conditional gift, it's basically an oral contract that he would give $2 million as a conditional gift. Now, interesting, there's usually something called the Statute of Frauds, which says that contracts for over a certain amount of money must be in writing. That amount of money is set in whatever law, and every state can have their own law, but it's usually around $500 or $5,000 or something. $2 million, $2.5 million would normally require a writing to get around or to fulfill the requirements of the Statute of Frauds. I'm not sure what effect that will have on Texas's case law on conditional gifts, but that's a thing here. Since there's $2.5 million at stake, usually you have to produce a writing to back up what the agreement was. The parties amended the terms, and there's $2.5 million at stake, and the thing was conditional. And he's continually notified defendant of his intent to revoke the conditional gift as a result of defendant's failure to comply with its obligations. And he goes into wanting his $2.5 million plus attorney's fees, costs, and expenses back. Conversion is when you take property that's not yours. So if a popular law school example is, if I grab your umbrella on the way out of your house because it's raining outside and I don't give the umbrella back, there's a threshold there someplace where I've now kept your umbrella, and that's conversion. I've stolen it. Might not have meant to steal it outright. I didn't go to your house with the intent to steal your umbrella, but I took your umbrella, maybe even with permission, but I took it intending to return it, and then at some point I no longer intended to return it, and it became conversion. So that's what that's describing here, and of course he wants his $2.5 million donation back. Count 3 is a declaratory judgment. Plaintiff has effectively revoked his conditional gifts, and so he's asking for a declaratory judgment that he is the rightful owner of the money. That might invoke something of a constructive trust. So follow me. He gives 2.5 million. They spend some amount of it. At some point, it becomes due back to him. That money is still his, but they have it, so they're holding it in trust. But it's not an express trust. He has not said, I am giving you this money and you can hold on to it. They're holding it by sort of accident or by circumstance. And it's his money and he's due back to him, so they're holding it in constructive trust. The trust has become, or the money has become held in trust now that the law or facts operate that the money is owed back to him. So that's a constructive trust. Although he doesn't allege that here. That's a law school exam question for you, I guess. Prayer for relief. Fred Eshelman prays the Honorable Court grant him the following relief: the declaratory judgment that he is the owner of the money, a temporary restraining order to preserve the money, the status quo, to prohibit defendant from dispersing any portion of his money while this litigation is pending, contractual and economic damages of 2.5 million at a minimum, his attorney's fees and costs, interest, and all other relief. And then, of course, he signs it. That makes it a verified complaint. We don't normally see this in federal court. You don't normally need to verify a complaint. But yeah, that verifies that he's seen this and the facts are as he says. So then the rabbit hole. So then there's this thing. We found this state of Delaware certification of formation or certificate of formation for Old Town Digital Agency, which is using what appears to be a registered office, which is perfectly legal, but a registered office is like an agent. It's one of those, like, it'll be one building with like a million mailboxes, and really it's just mail gets delivered to the registered office, and then the agent of the registered office will figure out who's supposed to get that mail. And it's where like corporations can be served with documents and things, and then the registered office agent takes care of that. Most states that I know of require LLCs and things to have a registered office. And so if they don't have a actual physical office, then this is sort of a shared physical office it's more like, a letterbox company or something. This is a legitimate thing, but it can also be the beginning of a money laundering operation or something like that, like a fraudulent operation. I'm not accusing anyone here. Let's be clear about that. I don't know, but this is the beginning of a rabbit hole. If we go back here to Firefox and I turn off my face so I'm not blocking the results here, we see that Dikran Yakubian, who appears to be associated with Old Town Digital Agency, is the president of louddoor.com and I think storylift.com. And there's some weird things on here that I'm really not going to go too much further into, but some people have discovered some things about this. For everyone crowd researching Louddoor, make sure you've seen this archived link. I have that link as well. The sites there are almost certainly all tied in. It has being conservative and many, many more that I'm sure I'll trace back to Louddoor. Dikran Yakubian was a Republican political consultant in Germantown, Tennessee. Bush 2000 was registered to Dikran Yakubian, and he owns a bunch of other website domain names, and apparently there's what appears to be a complaint here. And I don't mean a lawsuit complaint. I mean like a Curran complaint that he might be scalping internet domains, selling them at an increased cost. And I don't really want to go too far down this rabbit hole because we're going to get dangerously close to those politics that I don't really want to get into. But if we go back to here, Louddoor apparently has association with a whole bunch of domain names, as was found on that archive.org link that was linked there on the Twitter thing. And Louddoor is apparently something to do with impactful precision targeting. Louddoor empowers organizations of all sizes to cut through the noise and deliver persuasive and impactful messages to customized audience segments. So it appears that there was some kind of relationship between True the Vote and Loud Door for $1 million to do some kind of digital marketing or maybe creating videos or something. It says they do audience targeting, messaging and creative solutions, issue and candidate advocacy, winning political campaigns, affecting regulatory reforms. So it sounds like some kind of lobbying, which they don't use the word lobbying here, but that would be what affecting regulatory reforms. And they need paid content and advertising distribution strategies to do that. And you can click to start your project. So it sounds like they were a digital lobbying firm collecting $1 million, and then they suddenly canceled that. It sounds like True the Vote either didn't find their voter fraud or never went through with the complete efforts, but already had $1 million invoice from Old Town Digital Agency. And so that's weird. If I do a search for Old Town Digital Agency now, let's see what comes up here. There's not a whole lot. Like this isn't a company that seriously like comes up. There's Old Town Media, which I do not think is the same thing because that's Fort Collins, Colorado. And there's otherwise no anything here except a scribed link to Old Town Digital Agency, which is from Lachlan Marquet, which is, I think, somebody, let me see if I can find him on Twitter here. There he is. He is a Daily Beast reporter. And there's some interesting things here that if you want to go down this rabbit hole, you might be able to find some things about Old Town Digital Agency and Lachlan McKay's reports from the Daily Beast. And again, just some interesting rabbit hole stuff. There was somewhere here an allegation of, who's Old Town Digital Agency and what's the money being used for. So, very interesting situation that we've got going on there. So far, all we have of the lawsuit is the summons. So the summons have been issued to True the Vote, and I'm assuming the summons will be delivered by service of process at some point. Because it's a federal lawsuit, I believe they have 90 days to do so. I think it used to be 120, and now it's 90 days. So this is a very strange situation. On the best side of it, in True the Vote's favor, they thought that they would be ready for voter fraud efforts and then didn't find anything, so it had to stop, and they just need to wait for their invoices to come in. They need to do their own internal accounting, then they can provide an accounting to Mr. Eshelman and then give him back the balance of his gift, which sounds to me like the Occam's razor, the more likely scenario. But there's also kind of this speculating possibility that there was some kind of fraud going on within the organization, that maybe Old Town Digital Agency was taking money for something that it hadn't done. If there was an invoice sent but no work completed. It was canceled though, apparently at the first sign of resistance, so maybe Old Town meant to do a whole bunch of work and then didn't have to do the work. But it could also be that there was some kind of money laundering or donor fraud going on through that organization. That's very speculatory. That's not even my opinion. I'm just trying to give a bookend. It's either one or the other. And like I said, I think it's probably the former. They didn't find what they were looking for. They had to drop their lawsuits because they didn't have evidentiary support. We've even seen William Barr come out and say that there is no evidentiary support for massive voter fraud. Certainly, I'm not saying there's never anything in the form of voter fraud, but not at the level that was being alleged here. Tech Bub, thank you for the $5. Just tuning in. Can you give a quick summary of the case? Yeah, so Mr. Eshelman donated $2.5 million to True the Vote to investigate and sue over voter fraud. Either they didn't find voter fraud or they didn't complete their efforts, and now Mr. Eshelman wants the bulk of his $2.5 million back. The lawsuit says he wants all of it back, but he was willing to take just $2 million and they could have kept $500,000, but they didn't want to give that back to him, except conditionally they would give him $1 million back. Why that would be, I don't know. Maybe they did spend $1.5 million, or maybe they wanted to keep the $1.5 million. We don't really know. We're going to hear their answer to it. It takes 21 days to get that answer minimum. I mean, they can file anytime they want, but I'm assuming that once they're served, they'll file an answer in about 21 days, or they'll file a motion to dismiss, or they'll file some other motion, or they will make a motion for an extension of time, something like that. Laura Hertzman, thank you for the $20. Didn't Eshelman research this company before he gave the $2.5 million? Well, they said that they had Jim Bopp on board, and we saw from Jim Bopp's resume, he's the lead counsel in Bush v. Gore from 2000 and Citizens United from, I think, 2006. And that's a pretty impressive resume. So if I was the lead counsel in Bush v. Gore, what more do you need to know? I've already shown you that I can do the job, so maybe he didn't do further research beyond that. Maybe he has $2.5 million to blow, even though he has said that he needs the money back for other voter fraud efforts. So I don't know what's going on there, but we'll keep track of it and get back to you with any major updates. That said, now we're going to shift gears. I'm going to end this live stream, and we're going to go over to our Twitch channel, twitch.tv/lawfulmasses, and we're going to play some Jackbox games live for you. It'll take me about 10 or 15 minutes to switch over, so we'll see you in about 20 minutes. Thank you for watching. I'm Leonard French, your favorite copyright attorney. This is Lawful Masses, your favorite legal news and education program here on YouTube, also on Twitch, on Floatplane, and I think that's actually all where it is. Our supporters, however, are how we keep going. Thank you very much. We are a community-supported organization. Thank you to our supporters on YouTube members, patreon.com/ljfrench, sponsus.com/law, and our Floatplane members. In the month of December, thank you to our $50 plus supporters, Joe Tyson, Wes Delj, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., HotGrillsInYourArea, Oscar the Phrophet, Brandyn, Abel, Torpedan, Cassandra Curran, Mayor of Titty City, ShadowTycho, RDHDragon, Earthbound Star, No Copyright Violation Intended, and Nathan McCarty. And thank you to the $5 plus supporters. You've all been scrolling on my LED panel back here. I will see you all on twitch.tv/lawfulmasses in just a few minutes for some Jackbox games, and you can do some audience participation on our extraordinarily clever and childish answers to the various questions that Jackbox will ask. I think his name is Schmitty. So see you there. Love you all. Bye.